number 76, the Estate of Kainer versus UBS.
Should we move forward, Your Honor?
You may remain right where you are.
May I have 2 minutes for rebuttal, Your Honor?
You may, sir.
If this case, Your Honors, were a case about the theft of a sack of potatoes in Switzerland, which was later sold on the New York potato market, there'd still be argument, but you'd have a much stronger case for a forum non-convenience dismissal. And to me, the most important thing in the whole case here is it's not a sack of potatoes case. It's a case about stolen art looted by the Nazis, and that should weigh very heavily in the forum non-convenience calculation, and there's no indication in the opinions below.
Counsel?
Yes, sir.
I'm having a little bit of trouble understanding exactly what you would like us to do with this case. So, one issue is, should they have gotten a personal jurisdiction finding on the record first before they got to the forum non-convenience argument? And to that, I think we'd have to, if we agree with you, send it back and have them do it, but it doesn't seem like you want us to do that. And
Well,
then if we go on the forum non-convenience argument, normally what we would do, if they missed a factor, is undo that and send it back and have them do that again, and you don't want us to do that. So I'm having a little trouble as to what you'd like us to do.
Well, maybe, yeah, obviously I have an ideal result, and I have other results that I would ask for in the alternative, Your Honor. My ideal result is that you would determine as a matter of law, which is, I admit, an unusual case, but I think this is one, that they erred in granting the forum non-convenience motion, and on this situation, there was no alternative as a matter of law but to deny it. Obviously, if you don't reach that conclusion, then I would, yeah, it should be sent back, but I do think it's a matter of law. On the other problem you mentioned, it's obviously a very sticky one, because I do think the court was wrong in reaching forum non-convenience, and I think that's quite clear under Ehrlich-Bober, which is a holding, not dictum in my view, but they did it, and they wrote, and there are a couple of opinions out there, and what the reason I have the ambivalence that you comment on in my brief is I am concerned about a catch-22, where they say, congratulations, you win. You get 2 or 3 years of discovery on jurisdictional issues, and then they say the forum non-convenience holdings before stare decisis. So I've been wasting my time. So I would ask that if you are going to go that route, that you at least make clear that the decisions that have already been rendered improperly on forum non-convenience and in violation of Ehrlich-Bober, that they are not precedent, that they are not stare decisis, that they do not bind anyone, and that if the courts below later reach the forum non-convenience issue, they do it on a clean slate, without regard for the previous decisions. So I don't know if I've added to the conclusion or clarified it, but I do have that kind of hierarchy of preferences. Obviously, if you agree with me that as a matter of law, because of the inadequacy of the Swiss forum, the clear inadequacy of the Swiss forum, forum non-convenience was just out as a matter of law, and that Pahlavi is a sui generis exception that doesn't apply at all to this sort of case, well then, yeah, then frankly, I'll get over my jurisdictional hang-up. I will not complain about that result.
I'm sure you understand this, but let me explain my confusion. Sorry, over
Judge
here.
Wilson.
Thank you.
My understanding of your jurisdictional point is that if the court lacks jurisdiction, it can't rule on forum non. It simply has to dismiss. This is a question of the power of the court. Yet here you're asking us, your hierarchy, your first preference is for us to skip by the jurisdictional question and rule on the forum non, which seems to me, if you're right about the first question, we can't do. And if we do what you would like us most to do, we are, at least by implication, either saying we have the power or we don't care whether we have the power or not. And I'm having trouble putting that together.
I'm to be perfectly honest, Your Honor, I have trouble too. It is a messy situation. I do not purport to know whether I can, whether this matter of judicial power can be eliminated by my consent to a particular result.
Well, Mr. Smith, could we, under 327, under the language of 327, consider the impact of other factors that weren't considered in prior case law in the court? And specifically, the language of 327, as I read it, refers to substantial justice and a just result. And that seems to encompass the full equitable powers of whatever court is hearing the case. Does that offer an avenue for the court to address some of the contradictory complexities in the case?
Perhaps it does, Your Honor. Perhaps it does.
How so? What would you advocate?
Well, if obviously it would have to depart to some degree from Ehrlich-Bober to reach that conclusion, I think. Ehrlich-Bober does suggest that it's a matter of power. My adversaries are arguing that you should just overrule Ehrlich-Bober. I've pointed out that even so there's a problem. Even if you adopt Sinechem, there's a problem, because Sinechem left open a case like this case in which you can't get all the defendants in the foreign forum. And that's a even under the federal rule, there might be a problem with judicial power. However, I am receptive to the idea that 327 confers plenary equitable power to reach a just result.
If we reach that, would we, for instance, consider factors like the HERE Act, which I understand were argued below, and I'm not sure what was preserved in front of us or not by you on that argument?
It was preserved, Your Honor. The public policy was preserved in the, it's at 568 of the record, where this is before the HERE Act was enacted. But the brief says United States, the critical importance of the well-known United States and New York public policies as to stolen art. And the HERE Act was later specifically called to Justice Friedman's attention. So I don't think there's a preservation problem. I think and I do think those are absolutely critical.
Counsel, can I ask, what does the HERE Act have to teach us about forum nonconvenience? Because I thought it was a statute of limitations law.
I think you have to understand that the forum nonconvenience argument is an argument for sending this case to Switzerland, where there is a time bar, or at least my adversary says there's a time bar, and the time bar is absolutely essential to this case. Under the HERE Act, there is no time bar. In Switzerland, there may very well be a time bar. I'm saying that's sufficient as a matter of law to render the Swiss forum inadequate. And the complex issues that the lower courts saw, said, oh, there's these terrible problems of foreign law, all the opinions are abstruse. They're talking about the documents that were created before the HERE Act existed. The HERE Act simplifies things enormously, and what also simplifies things enormously also after the case was submitted before it was decided was the German appellate decision, which essentially knocked out my adversary's only argument on the merits. There's no question about who the heirs are here. I'm representing 11 of them. The German courts have rejected the idea that the foundation is the heir of Norbert Levy, and the only thing left is the theory that these paintings escheated to these two Swiss jurisdictions because Margaret Kainer died without heirs. Well, she didn't die without. I'm here, standing here, representing 11 of them. They'd have to prove my 11 clients don't exist, all 11. So there's really no issue.
Well, I thought there was more complexity. I thought that Norbert's will had a provision that if his daughter had no direct descendants, that it's a provision that wouldn't be allowable under American law, but I assume it's still allowable under German law at that time.
Well, the German court said, no, the German court said...
She had no direct descendants that went to this foundation.
The German court rejected that, the German court tossed out the appellate court, the appellate decision rendered in December of 2015.
But the problem for you is that the foundation is a Swiss foundation, not a German foundation.
Yes, but the foundation has no claim to inherit from Norbert Levy under Swiss law. That's a German law question. They have not challenged in any way the German decision, and they're not claiming in Switzerland as the heirs of Norbert Levy. The heir of Norbert Levy is out of the case since December of 2015, sorry, not quite that long ago. They talk very generally about, oh, well, there's such complicated questions about who the heirs. No questions about who the heirs are. They're my 11 clients, that's all there is to it. The question is whether they're time barred. They are there, they're not here. That's all there is to the case, really.
Counsel, doubling back to something that I think one of my colleagues was asking about, your representation as to what the holding is in Ehrlich Bober.
Yes.
If we were to disagree with your representation, is there any other binding precedent that you're aware of that we can look to?
Binding precedent on that issue other than Ehrlich Bober, not that I'm aware of, Your Honor.
Okay, thank you, counsel. Thank you.
you.
Counsel?
Good afternoon, Your Honors. May it please the Court. Despite, as Your Honors have noted, despite plaintiff's position in the courts below, parties seem to agree that the courts do have the power in the appropriate case to decide the forum nonconvenience issue before definitively deciding that it has personal jurisdiction. The Ehrlich Bober case on which...
Can I stop you there?
You may.
If we assume what you're saying is correct, are we in essence adopting the Supreme Court's decision in Sino-Kainer?
I think Your Honors should adopt the Supreme Court's decision.
No, but I'm asking you, if we do that, if we follow that, are we implicitly adopting
You
it?
are implicitly adopting it. There is no possible way that you can do what the plaintiffs are asking to be done here without deciding that the courts do have the authority to decide forum nonconvenience before deciding personal jurisdiction. Ehrlich Bober does not hold as a matter of law that the courts cannot do it. It was dicta in Ehrlich Bober because it was not necessary to the court's decision. The court denied both the personal jurisdiction motion and denied the forum nonconvenience motion. It did not present the case that we have here. If Your Honors look back to where the statement comes from in Ehrlich Bober, it comes from a footnote in the appellant's brief in that case. The appellant cited for their argument the Gulf oil language that Justice Ginsburg in Sinochem says does not stand for the proposition that the court may not decide forum nonconvenience first. Gulf oil, just as Ehrlich Bober, has some confusing, less than carefully written language, but it is not the holding of the case. And Justice Ginsburg in Sinochem quite clearly said, sure, if we have decided that the court has no personal jurisdiction, we should dismiss on that basis and go no further. The court does not say, and Ehrlich Bober does not hold, that the court may not decide forum nonconvenience before deciding personal jurisdiction. It would be completely contrary to the whole purpose of the forum nonconvenience doctrine, which is to serve considerations of convenience, fairness, and judicial economy. The catch-22 that appellant's counsel talks about here is exactly the problem with a rigid rule that would force the court to decide personal jurisdiction first. If Ehrlich Bober...
I'm sorry,
Sure.
I take your point on Ehrlich Bober. I read it slightly differently. It seems to me Ehrlich Bober is unique and not quite relevant in a couple of ways. One, I think you were getting at, which is the real issue there was comedy and whether they were going to keep the case.
Absolutely.
So preliminarily, they had to address this forum nonconvenience argument, and they were keeping it. So in the forum nonconvenience argument, they had to address both the forum nonconvenience and the underlying personal jurisdiction. Otherwise, the court wouldn't have been able to keep the case. What aggravated that to me is the appellate division decision in that case, which is unusual because it's a big dissent with a short majority that adopts kind of some of the facts from the dissenting opinion, because again, they were talking about comedy. So in the forum argument, they kind of are playing off of a dissent, and I think what Judge Walker was doing and Ehrlich Bauer was saying, reading that, we're going to assume the appellate division found X and then found Y. Not that you have to do that all
Absolutely
the time.
right, Your Honor. It really was a comedy case. It is dealt with quickly at the beginning. It's not something that the parties engaged on. Unlike this case, where the question was squarely presented to both lower courts, can the court first decide forum nonconvenience, or must the court first decide personal jurisdiction? It was squarely presented in this case. It was not squarely presented in Ehrlich Bauer at all, Your Honor. It was mostly a comedy case, as you said. I want to address the HERE Act for a moment. I don't think this court has the ability to rebalance the factors, to rebalance the considerations that were argued below. That's not this court's job. The abuse of discretion standard commits the decision on forum nonconvenience to the courts below. Here we have clear, careful findings from both the trial court, the motion court, and the appellate division on some of the most, the relevant factors. Where are the witnesses? Where are the parties? Where are the documents? What law is going to apply? The court balanced all those factors. The court was presented with the HERE Act argument, at least in the appellate division.
Let me ask you this, though, on the factors. I think you make a fair argument, and I don't know if I agree with you, but it's a fair argument. It's a reasonable argument. But it seems that we're confronted here with some of the consequences of what is arguably the greatest crime in human history. And in that situation, are we limited in applying what we consider substantial justice to the lower court's specific balancing of factors that we may personally disagree with, but doesn't seem to have balanced or have been able or felt that she was able or he was able to include that kind of a factor in the same way that the HERE Act would have included that kind of factor in balancing the justices and reaching substantial justice? Aren't we required in that circumstances to reach outside kind of the constrained, constipated jurisprudence that seems to hold back an examination of the principles of substantial justice to a very, very unique situation? Aren't our constraints somewhat different here than they would be in another case?
I don't think so, Your Honor. The courts below were presented with these arguments. At least the appellate division was. The HERE Act was not argued in the motion court as a ground for keeping the case in the United States.
But my argument is based a little bit broader than that. It's based on the language in 327 itself, which talks about substantial justice and reaching a just result.
Well,
anyway, you go ahead.
Reaching a just result also requires consideration of the important considerations of forum nonconvenience. That is an important consideration of the New York courts, to not be forced.
The language itself is revelatory. We measure convenience against justice. Justice is always going to win. We'd all agree with that. So does the inconvenience reach a point where you can't have justice? That's what we have to look for, right?
Perhaps in some case that is right, Your Honor. But justice also requires that we be able to, it's not just convenience, that it would be unjust to require litigation of this case in this court, in the New York courts, because it hinges on what people did in Switzerland and Germany and France years ago. We could not compel those witnesses to be here at trial. We are faced with a situation where there could be conflicting rulings of Swiss courts that are deciding the very same remedial relief that is sought here, namely an award of damages related to the painting and the other assets of the Kainer estate. It is unjust to force this case to be litigated in New York. I understand the concept and the principle that the courts of the United States and New York want to give the ability to remedy what is a grave injustice of historical proportions. But that's not really the question that's to be asked. Is litigating this case just, convenient, and efficient to be done here in the United States? And I think the answer to that is no. And even if you thought that, Your Honors, if you thought that there was a factor that the lower courts did not properly consider, the right outcome is remitting it to the appellate division. CPLR 5613 says as much, that if this court concludes that the lower court failed to consider something that it should have considered, it shall remit to the appellate division for further consideration. Now, I don't think we need to get there, Your Honors, because the lower courts did consider these arguments. The argument that it was somehow overlooked is inconceivable. It was a linchpin of their argument in the appellate division. The court below said, we have considered plaintiffs' remaining contentions and find them unavailing. The argument here is, well, that's boilerplate. But that's really an accusation that the appellate division didn't do what it said it did, namely consider the other arguments. There's no requirement that the appellate division go point by point by point by point through the appellant's brief and rebut it. And even if you thought it had been overlooked in the initial decision, they moved for reconsideration on the ground that the court had overlooked it. And the court denied that motion, indicating that, in fact, it did not overlook it, because had it overlooked it, it would have granted reconsideration and done what it needed to do. Thank you, Your Honor.
Thank you
Thank
for
you,
your answer.
counsel. Counsel, your rebuttal?
Yes, I think the main point to make, Your Honor, I don't view this as a balancing case at all. My point is that we have a forum in Switzerland that is inadequate as a matter of law, because there are very grave impediments to reaching the merits. Indeed, the only defense he has is don't reach the merits, because he doesn't have any defense on the merits. That's why he wants to go to Switzerland. Where there is such a situation, I'm suggesting to Your Honors, as a matter of law, a forum non-convenience motion may not be granted, because you may not send a case to an inadequate forum unless you have the sui generis Pahlavi situation, where the Islamic Republic of Iran was saying, oh, please don't send me to the Islamic Republic of Iran, their courts are all in turmoil. And this court said, in effect, give me a break, it's your courts. But to take that as carte blanche, as perhaps some lower courts have, to say, oh, we don't need to worry about the adequacy of the foreign forum, that's just one factor we can balance away, and we balance it away by saying we've considered your other arguments and they lack merit.
But counsel, isn't choice of law one of the issues that would have to be decided in the New York court were this litigation to go forward here?
The choice of law issue on the time bar is easy, Your Honor. The HERE Act chooses the law for you. There's no statute of limitations bar. On the merits, the only really debatable issues relate to Christie's role in the auction in New York, to which New York law should apply. And yes, they would have that choice of law decision, but I think I think it would be made in favor of New York. Speaking of the choice of law, I want to refer Your Honors to the Second Circuit decision by Judge Corman in the Bacalar case in 2010, which explained how a choice of law decision can be informed by the contrast between the Swiss court policies, very hostile to the claims of Holocaust survivors, and the New York policies favorable to those claims, and that should impel a court to choose New York law. I would say that by the same token.
Well, it's not just Switzerland, is it? I mean, we have France, there's litigation there, there's litigation going on in Germany, I think. You know,
Not anymore, Your Honor.
That's over now?
No, the only litigation is in Switzerland and here. We won in Germany, and his defense disappeared when we won in Germany. I think the problem is that happened, and the HERE Act was passed while the case was sub judice before Justice Friedman, presumably when she's already working on her opinion. And you see, she does talk about the HERE Act, and she does talk about the German appellate decision, but she talks about them as afterthoughts. I'm suggesting that they're central, that they simplify and transform the case, and that they make it impossible as a matter of law to send this case to Switzerland, because all you're doing is sending it to a case that's going to hinge on a policy absolutely contrary to the policy of the United States and the policy of New York, and that's error as a matter of law. It's not balancing.
Thank you, counsel.